Hi, good afternoon, everyone. Delighted to welcome you to this Contractual Update 2022 session. So a review of the case law from last year. We are going to give you another couple of minutes to get the last few people in. I have a bet going on with Heather to see how many we actually get through the door. So I have said I'll give it till 12:32 before we actually start. So you do have a couple more minutes just to grab a brew, pop to the loo before we actually kick off this session. Thank you very much, and speak in a couple of minutes. Okay, I can still see we've got quite a few more people joining us at this point. We are about to start this session. So let me give you the introductions. Today's session is a contractual update session. What we're going to do is have a look back over 2022 at some of the most important or interesting cases that came along. My name is Geraldine Fleming. I'm the lecturer for this particular webinar. And I'd just like to say a big thank you to Heather, who got me on board to do this particular session. A couple of things to note. This particular session will be recorded and it will be available on the Chartered ISIS website for a limited period. The slides will be available, but you need to actually send either myself or Heather an email, and then I will distribute the slides after the session. In terms of questions, we've decided that the best way for you guys to ask questions is to use the chat function, and hopefully you can see that little bar. The chat item is actually the last one. If I get time as we go through the session, I will answer the questions as we go along. If there are too many questions, then obviously I will get a report from Heather and I will answer you individually over the next few days. Hopefully this session will look at some of the interesting and maybe scary cases that came up over the past 12 months or so. A little bit about the company I work for, first of all. I work for a company called Driver Trett, which is part of the Driver Group. Now, I get very, very few opportunities to put pretty pictures on the slide, so I have taken a bit of liberty here. It's some of the pictures. I'm going to admit I've never worked actually on an aeroplane project myself, but that's an example of transportation that some of our guys have worked on. The Driver Group itself is a market leader in expert witness planning, commercial, technical, dispute avoidance and dispute resolution. You'll see on the screen that we have specifically highlighted dispute avoidance there, and that is absolutely the purpose of today's session. Company was established in 1978. We are stock market listed with offices around the world. For those who are based in the UK, a very pretty map on the screen at the moment showing our local UK offices. I work out of our Hooton, Cheshire office with our head office in Haslingden. Three main parts of the business. On the left-hand side, we have driver project services, and we essentially provide people onto live construction projects. In the middle, we have Driver Trett, and that's the part of the business I work for. And I like to describe it really as a cradle to grave service. So we can provide training and contract advice up front in relation to what you're signing up to. We can give advice as the contract proceeds, and obviously advice in relation to the final account and the settlement. On the right-hand side, we can see Dialis, which is our expert witness division. We have experts in quantum, delay, and also technical experts such as architects and engineers, as well as adjudicators, arbitrators, and mediators. Now, I know you're all going to absolutely request a copy of the slides, so I'm not going to read out all the ways that we can help your business. Again, I've highlighted a few in red for you there. I do like giving people, I'm going to say post-webinar reading though as well. And we do produce a magazine twice a year. The most recent one is the Dialis Compendium, which celebrates 10 years of us being in business. And there are a number of interesting articles, not just that ourselves have written, but we also get people outside the business to write as well. A little bit about me. Yes, I'm a quantity surveyor. I'm chartered. I worked for a main contractor for 5 years as a site QS. I then went on and did a law degree and my solicitor's exams, but I'm not a solicitor. And I work in that area between quantity surveying and contractual issues. I've been in construction claims consultancy for 20 plus years, and I'm not going to let on how much the plus is at the moment. What are we going to cover today? Well, I've picked out 6 areas. I actually could do probably a 3 to 4 hour session on the things that came up over the last year. But for this session, I'm only going through what I consider to be the more important or the more interesting ones. And the first one is a very juicy subject, all to do with bribery. Now, I have to say the construction industry as a whole does not have a good reputation in relation to this particular area. And the case we're going to look at, unfortunately, does not represent the industry in a very good way at all. Now, we are doing a 2022 update, but I am going to go back a few more years. And I'm going to go back to January 2019 and a report from the BBC website. And I've paraphrased this particular report. So I've literally just downloaded the news report. And the news report said, a project manager has been found guilty of fraud. Paul Galbraith submitted invoices from a non-existent company for work that had not been done on a business development at Whitburn in West Lothian. The jury at Paisley Sheriff Court took less than an hour to find him guilty. Just have a look at the numbers here. £513,200 was paid into an account in Galbraith's mother's name. He used it to buy property, services and designer goods, including a property in Inverkip in Inverclyde, which he bought outright, £3,600 on a Louis Vuitton handbag for his daughter, £10,000 spent at Hugo Boss over 8 months, £4,500 at Watches of Switzerland, over £4,000 at a private members club in Glasgow, £3,000 in one day at a 5-star hotel in Dubai, and £15,000 on flights and holidays, including a trip to Australia. I have to admit, I like the last line here. He spent so much, the account was briefly overdrawn. Now, as Heather well knows, if I see an opportunity to try and make people laugh a little bit on these seminars, I will take it. And again, we're still on this BBC website report. Have a listen to this bit. His mother told police that her son had always enjoyed the high life. It always had to be the best of gear, she said. With my other son, you could go to Primark and buy him a shirt and he'd be over the moon. With Paul, you'd have to go to Top Man. So there you go, a bit of advertising in here. So a little bit more background. Galbraith was employed as a project manager with a company called Space Solutions on this development in Whitburn on behalf of a company called Oil States Industries UK, which was the Aberdeen-based arm of a US firm. He protested his innocence, claiming the money was an incentivized bonus. Now, be interesting to know if anyone listening into this session had ever had a bonus of this size. So this incentivized bonus would see him receiving more than £750,000 if, in his words, he could get the construction phase of the development up and running earlier than planned. I'm not seeing people writing in the chat at this point saying, yeah, that's a common occurrence at all. So let's move across to 2022 now. And this is a case between Oil States Industries and, as reported in relation to the court case now, between S Limited. So it's a Scottish case, so we will see slightly different terminology here. The pursuer, which most people would refer to as the claimant, was Oil States Industries. Again, you will remember that from my previous couple of slides. And the defenders, or again, often referred to as the defendants, the first defender was this company S Limited, and the second was Lagan Building Contractors. Now, the project management services provided by S Limited was for procurement advice and the administration of this procurement process for the office and production facilities at this business park. And it was S Limited, the project manager, who appointed Lagan to build the project. And it won't surprise you to know who S appointed as the project manager was. It was indeed Paul Galbraith. S Limited, so the project management company, said it knew nothing of these bribes and that Paul Galbraith was now a former employee. It was Lagan, so the second defendant, who allegedly paid the bribes. Now, as well as everything else that was reported on the BBC website back in 2019, we also find out that Paul Galbraith's sister, Lindsay Cole, had building work completed on her house by a firm called Apple Orchard Construction, again funded through the monies that Paul allegedly received. In addition, in this court case, we find out that cash was allegedly paid in Morton's Club in London and also in the Witchery restaurant in Edinburgh. And there were two issues that the court looked at here. Question one, did Mr. Galbraith receive a bribe? Now, again, this is a case in 2022, and I told you about what happened to Paul back in 2019. That's the first one. The second one, I think, is the more important for this particular case that came out in 2022, is whether S Limited are liable for the bribes that its employee accepted when it was advising on the selection of a contractor. Now, there's big money at stake here. We have damages of 12 million that Oil States were claiming from S Limited, and of that, £10.5 million was due to the award of the contract to Lagan that was procured by bribery. Now, we need to know what a bribe actually is. It is a form of secret commission or secret profit paid to an agent. And this case did involve the recovery of deleted emails from a laptop. That's something that we're going to come back to at the end of this session as well. We're going to introduce another party here as well, Odin Consulting Engineers. Now, Odin were the engineers employed on the project. Do you remember S is the project manager and Paul Galbraith works for S. Oil States Industries are the client. Excuse my language for this next part. The first email that the court looked at was dated 21st of May 2013. Just let's think about this. This is a case in 2022 where Paul Galbraith had already been through the criminal courts back in 2019. It takes a long time for a case to get into court. So what did this first email say? Again, hopefully Heather has got the bleep button at this point. The first email said, fucking phone all but grubbed again. We have green light, read the above, but there is a complication. My new best pal expects a bag of sweeties. Now, some of you may be thinking, does this refer to Maltesers, opal fruits, maybe a marathon? Unfortunately not. The response came back on the 24th of May 2013. Here is my starter for 10. Oil States needs a contractor. Lots of industrial. Lagan would be ideal and are looking to continue at the new LE project. We do our utmost to get Lagan in on Oil States. Possible sweeties to Paul Galbraith from ML. Mike runs the job for them. We get some sweeties for making it happen. Mike returns a favour to Lagan by making sure that they get LE too. We get more sweeties. It is fucking beautiful. David Irvine's reply to that, in large bold font, underlined, was absolutely fucking brilliant. Graham, I am looking forward to tomorrow. And then I think the killer line, believe in yourself, with rather a lot of exclamation marks. What happened next? The court pointed out that the standard of proof in a civil case is on the balance of probabilities. So in other words, is it more likely than not that Mr. Galbraith received a bribe in relation to Lagan being appointed on the job for All States? The judge, and some judges, they have got a gift in relation to their judgments. This particular example, the judge said that the Sweeties email colours all subsequent events. In other words, that the quotation that I will not read out again very much points out that actually there was monies swapping hands that should not have been swapping hands. Also, Mr. Galbraith's conviction and imprisonment for a bribe for fraud reduces, again, great wording from the judge, reduces the improbability of his accepting a bribe. And they also looked at the fact that monies were paid to a builder that was working on Galbraith's sister's house. The court held, do you remember there's 2 points here? Number one, Mr. Galbraith did receive a bribe. Now, I think all of us would have agreed that that was going to be the case given the 2019 criminal case decision, but importantly, that also Mr. Galbraith's employer, S Limited, was vicariously liable for the fact that Mr. Galbraith received a bribe. Now, this is like getting to the last page of a whodunit Agatha Christie book, and you're desperate to find out who did it and what did they use. Was it the candlestick in the library? And unfortunately, the last page has been ripped out here, because whilst the judge actually handed down his decision, he also admitted that there had been a confidential settlement in this particular case. So if you remember the figures, the Oil States were looking at a figure of £12 million to be paid to them for what happened. We actually have no idea how much money then changed hands to settle this particular case. So it could have been a settlement for 5 million or 10 million or somewhere in between or over or above those figures. You've also got the costs to think about as well. Given how far this case went, I am guessing here, but I would believe this S Limited would to have had to have paid Oil States a significant amount of money, bearing in mind what came out in relation to the emails. So a couple of things. Number one, don't accept a bribe. Number two, don't offer a bribe. Number three, if you're an employer, remember you are vicariously liable. And so if you see people walking around with a very expensive kit, boasting about what they have recently bought, I think probably you'd want to see their lottery ticket, or you might see some smoke signals going up in the air. The next subject is something that I am much more familiar with, and of course a lot of you will be too. It's all about the money. So this is looking at some of the payment cases that have come out within 2022. I've included in the notes a copy of a particular chart in relation to payments Just going to bring down, of course, the lovely love letter, the pay less notice as well. So most construction contracts have payment terms that look something like this. This is the NEC 3 version. Of course, you can have contract amendments that perhaps change the period between the due date and the final date for payment. A VAT invoice might be something that's added in as a requirement, but essentially, this is roughly how the payment regime works. From the left-hand side, subcontractor issues an application, valuing the works up to an assessment date. X days later, there's a due date. The paying party gets two opportunities to say that they're not happy with the amount in the application, either a payment notice or a pay less notice. If either of those two aren't issued, the amount in the application, assuming that the application is properly issued, becomes the amount that has to be paid by the final date for payment. I think my record is 3 hours solid talking about payment issues, and I haven't got time for this, so let me move on and tell you about the couple of cases here. The first one, Bexheat and Essex Services Group, an unusual case because it's low down the food chain here. This is to do with a residential and care home between Essex, who are the subcontractor, and Bexheat, who are the subcontractor, so down the chain. Plumbing works here were worth £1 million and disputes arose regarding money. There were two adjudications here. Rather unusually, the first adjudication was all about the true value of the account. This was all to do with the works that had been completed up to July 2021, and Bexheat, the subcontractor, issued application for payment number 22 on the 19th of July. Absolutely perfect. It showed a gross of 1.8 million, so just note, significantly more than the original contract sum. And there was a net figure of £678,000. I think Bexheat got the red pen out and significantly went through the account and said, actually, Bexheat, you're only entitled to 1.1 million gross, and this time we're only going to be paying you £5,000. So that's the money that was physically paid over. Bexheat were not happy and took the matter to adjudication. The adjudication started on the 18th of August 2021. I want you to remember that date, 18th of August 2021. And this particular adjudication was all about the true value of the account. The decision came out on the 12th of October, and Essex were held to pay Bexheat 1.3 million gross, or around 141,000 net. So it's a nice amount, significantly less than Bexheat had claimed, but significantly more than Essex had actually paid. Now, I have to admit, I always like to look at the split of the adjudicator's costs. And here, the adjudicator decided a 65-35 split, so roughly 1/3, 2/3. It's very difficult to even guess what an adjudicator will do with their fee. Another adjudicator with exactly the same facts might have said, well, actually, Bexheat succeeded in getting paid more money, so Essex should pay 100%. Or another adjudicator might decide on a 75-25% split. Every single one of these is different. So nothing too unusual or exciting about that first case. Keep in mind that here, the first adjudication started on the 18th of August. So what then happened? We have adjudication number 2. The application for payment was issued here on the 17th of August, valuing the work to the end of the month. Again, absolutely perfect. And I think most of you are going to guess what happened next here. The application, gross of 2 million, net of 706,000. It was another 30,000. The pay less notice here from Essex was issued late. It wasn't issued until the 13th of October. If I was guessing, why did this happen? If you imagine that you're the person receiving the application, you get the application in, the next day you get an adjudication, and you forget that you've got an application to deal with. You forget to do your day job because something much more exciting has hit your desk. And that's why the pay less here was late. So what did Bexheat do? Well, they actually started a smash and grab adjudication. They'd issued a perfect application. They hadn't been paid the full amount. There was no valid payment notice, no valid pay less notice. So therefore, they're due all the money. And indeed, when the decision came out on the 12th of November, it was held that Bexheat were entitled to every penny, plus interest, plus statutory compensation. And this time, Essex had to pay the full amount of the adjudicator's fees. Guess what? Essex didn't pay. So it goes to court, and that's why we're talking about this case today. Basically, Bexheat are saying, look, here's my adjudication number 2 decision. I just want paying the monies that are outstanding. On the other hand, however, Essex said, hang on, adjudication number 1 is binding. Therefore, adjudication number 2 should be assessed as nil because adjudication 2 should have been decided in line with adjudication number 1. If you go back to adjudication 1 on the true value, I would imagine that the poor adjudicator dragged themselves and valued each and every variation on the project to get to the amount that was due. And now we're saying, or now Bexheat is saying, forget adjudication number 1, look at my much more interesting adjudication 2 decision. It was held that Essex had to pay adjudication 2 regardless and totally ignoring adjudication number 1 because the disputes were entirely different. You cannot set off adjudication number 1 and number 2 against each other because they're different. You couldn't join the disputes together. And Essex, I'm kind of seeing this as a little bit of desperation coming in here. Essex said, we shouldn't have to pay this because Bexheat are in financial difficulties. The fancy term for that is manifest injustice. You know, when you check your lottery ticket on your phone app and it comes up, not this time, you feel manifest injustice. That's exactly how Essex felt in this decision. The court said, no, I'm not having any of that. Essex, you have to pay Bexheat in full. What could happen next? Well, actually, what could happen next is that the money has to be paid across and the money stays in Bexheat's account until Essex start a third adjudication, which is a true value adjudication on the back of the August application. I think there's 2 parties here who are rubbing their hands with glee. Number 1, the adjudicator, and secondly, the representative parties from both sides here. And remember, this has happened all because Essex didn't issue a notice. If they'd have issued a payment notice or a pay less notice, we wouldn't have had this very exciting case to look at. Another one in the payment area. Main contractor here is an organisation called Advance JV. Now, Advance JV includes Balfour Beatty, it includes MWH. So it's a JV in relation to some works that are being carried out. The subcontractor here is a company called Eniska, and they were doing the design, supply and installation of the LV installation. Works began in October 2019 and they carried on. And we get up to application for payment number 23, which valued the works up to September 21, and everything was fine here. well, it was fine up to a point. Aniska wanted a gross of 3.7 million. However, they only received a gross certificate of 2.3 million, which meant that there was a delta or a difference between the parties of 1.4 million. So, yep, everyone did what the contract said, but Aniska weren't paid enough money in their view. So they issued another application, number 24. Now, I think they certainly added some more lines to the Excel spreadsheet, got their calculator working a bit harder than before, because this time the gross for application 24 for works up to the end of October was a gross of 5.1 million, with 2.7 million outstanding. And then application number 5, it just tweaks the numbers up a little bit. So to the end of November 21, it was a gross of 5.2 and 2.8 million outstanding. No response was made by Advance to Aniska's application for payment number 24. However, what Advance did do on the 24th of November, which was the penultimate day before a payless against application 24 could be issued, they did upload a payment certificate and a payless notice, both against application 25. Both documents showed that no monies were owed, and actually 164,000 was owed by Aniska to Advance. What happened next? Well, it kind of feels a little bit like the Bexheat and the Essex case. In January 2022, application 24 was referred to adjudication. Remember, 23, all the notices were done. 24, the notices weren't done. 25, the notices were done. So Aniska have gone back a few months here to October. Aniska argued very simply, there was no payment notice, there was no payless notice. We want the full amount, the gross of 5.1, the net of 2.7 million. Advance came up with what I think is a very interesting argument. They said that because the payment certificates and the payless notice against application 25 were in time against application 24, they were therefore valid against application 24. In February 22, the adjudicator gave their decision and said, not a chance, Advance. Aniska, you are correct. You are awarded 2.7 million. As you can imagine, Advance did not want to pay £2.7 million that they didn't think was owed. So they started what's called a Part 8 claim, saying that the Payless Notice 25 was valid against application for payment 24. And off we go to court. Again, I want everybody to be thinking here about the costs side. The Technology and Construction Court agreed here in full with the adjudicator that payment notices and payless notices must be referable to individual payment cycles. They rejected the argument that the Construction Act is only concerned with time limits. They rejected the argument that a payless can respond to 2 applications. Now, do you remember on the last case? Again, judges have a lovely way of putting things down. I think what the judge really wanted to say here was, this is a rubbish case, but he didn't. Instead, he said that Advance's argument was a novel proposition for which no support can be found. Very, very nicely worded. Advance's Part 8 claim was dismissed and Aniska got the 2.7 million quid. The moral of the story, do your payment notices, do your payless notices, otherwise you might be facing a smash and grab adjudication. Which leads us nicely on to adjudication itself. The case I'm going to look at here is all about whether a notice was served correctly or not. And the parties here are AM Construction and the Darrell Aman Trust. Now, it's not too important in terms of the facts of the particular case. A JCT contract, 2015-2016 contract period, 3-storey mosque with a 2.3 million contract sum. The parties fell out. There was an adjudicator's decision on the 19th of November. AM Construction said that the adjudicator's decision is unenforceable. The Darrell Aman Trust said the decision is enforceable and they wanted their money. Now, I want you to think of those people on the session today. Have you got a Ring doorbell? Can you believe that I can actually get a Ring doorbell into an adjudication case? Well, actually, I have a Ring doorbell and I used it yesterday when a delivery company said that they had tried to deliver something to me, and I gave them a printout of my Ring doorbell and showed them that nobody had pressed the doorbell on our house, and I asked them what they were playing at, lying to me about attempting to make a delivery. I am waiting a response to my email on that particular issue. By all means, ask me again in the future about how I got on with that particular case, because it is quite funny. But anyway, in this particular case, remember a Ring doorbell. And it's all about whether this decision was enforceable or not. On the 4th of October 2021, the DAT, Darrell Aman Trust, used a process server to issue a notice of adjudication to AM Construction. But what was in the envelope? AM Construction said there was no notice of adjudication in the envelope. Remember that AM Construction want the decision cast aside. The next thing that happened was that AM received the appointment of the adjudicator documentation, and AM said that this was invalid because it came the wrong way round. You can't appoint an adjudicator before you've issued the notice of adjudication. DAT's solicitor gave a statement that the notice and other documents were issued and sent to a process server, and the solicitor produced a copy of their email to the process server showing the documentation. No issues there. The process server stated that they'd called at the house and rang the doorbell at 3 o'clock and there was no answer. They'd called at 4:22, there was no answer. So they pushed the documentation through the letterbox, and that all documents were in the envelope. However, there was video footage, and the video footage from the Ring doorbell said that no one had pressed the ring button at 3 o'clock. Equally, no one had pressed the button at 4:22, but it did show the guy pushing the document through the letterbox. AM's statement said, here's our video footage. The envelope contained a contract, but it didn't contain the notice of adjudication, and they'd sent it to a solicitor for review. Now, this is one of those cases. The judge doesn't know what was in the envelope either. The judge preferred AM Construction's evidence that there was no notice of adjudication. He was particularly persuaded by discrepancies between the process server and the video evidence. Essentially, he said, look, the process server is seriously has lied here. He hasn't done what he was supposed to have done. Therefore, I believe AM Construction more. He found the notice of adjudication wasn't served, the appointment of the adjudicator wasn't valid, and therefore the decision was not enforced, all because the process server said that he rang the doorbell and he didn't. So, well, I could say the moral here is make sure you ring the doorbell, or alternatively, I could say make sure that you issue the notice of adjudication properly. Moving on, but still in the area of adjudication, the next case is all about whether an adjudication is binding or not. And it's all about looking at what can be reopened in relation to an adjudication. And in this case, There's lots and lots of information there. Again, it's a JCT management contract, 26 million. There was a final account dispute. There was a delta or a dispute here of 17 million. The employer wanted 11 million back. The contractor wanted 6 million quid more. Goes to adjudication, and it was held that the contractor had to pay the employer 1.8 million. In this case, the adjudicator did a split on the fees of 50-50. What happened next? Well, the contractor wanted to open up the previous adjudication in future proceedings. In Part 8, so in other words, this case went to court, the employer wanted a declaration that the adjudication was binding when determining the final account. Now, I have to say, this is complicated. Point 1, an adjudication is binding until it's finally determined, so it can be reopened in litigation or arbitration. The decision is binding on, say, a final account adjudication for variations, unless a new basis of claim for a variation is put forward, which allows the variation to be opened up. But it's not binding in this particular situation in relation to the final determination of the completion period and the validity or otherwise of extensions of time and imposition of liquidated damages, because the JCT contract itself says that once practical completion has been achieved, that the time implications can be reviewed post-contract. Now, I think this would be different under NEC 3 and NEC 4. NEC 3 expects everything to be agreed as the job progresses. NEC 4 has a final account procedure in it. I think we will see more cases which will hopefully clarify the binding and non-binding elements of an adjudication on future adjudications. Another case that came up in relation to whether an adjudication is binding, a very big case here, Northumbrian Water and Dewson and Tilbury Douglas. An NEC contract to do with Horsley water treatment works, and this was all about termination, with one party saying that the termination is valid and the other party saying that it was invalid. The adjudicator decided here that the client was owed £22.5 million by the contractor. The contractor then issued a notice of dissatisfaction and did not pay. So Northumbrian Water started proceedings because they wanted the £22.5 million. The JV claimed that it was allowed to stay or pause or stop the proceedings for the payment under the Arbitration Act. And the court weren't having any of that kind of nonsense. Quite simply, the judge here said, we are enforcing the adjudicator's decision and the contractor has to pay the £22.5 million. They noted that the JV took part in the adjudication without raising any jurisdictional challenges and accepted, therefore, the validity of the adjudicator's decision. The decision was final and binding on those matters and was enforceable, and quite simply, the Arbitration Act was entirely irrelevant. Okay, quickly on to a case involving both termination and delay analysis. The glamour of some of the jobs we get involved in. This was a new bus station in Blackburn with a start on site in March 2014 and a completion date of January 2015. There was no signed contract, but everyone agreed it was a JCT standard building contract with quantities, and the contract sum was £4 million. This is what the client was expecting, and that's a picture of what they got when termination occurred. So, what happened here? There were 3 default notices issued in April and May, and then on the 5th of May 2015, the client, Blackburn with Darwen Borough Council, issued a non-completion certificate. At the end of May 2015, Thomas Barnes, the contractor, left site and suspended the work because of non-payment. On the 4th of June, a termination notice was issued by the council. It confirmed that the council was terminating in accordance with the contract, but in the alternative, it accepted Thomas Barnes' repudiatory breach. Now, importantly, the method of sending such documents is very important. The letter was sent by email. It arrived on the Thursday by email. It was also given by hand to site, and the official copy arrived at the registered office on the following Monday. Now, on the Thursday, when the email arrived, the council picked up the phone to Thomas Barnes and said, "We are taking over the site." They did not wait until the Monday. Now, the court pointed out that emails are not valid because the contract required notices to be sent by recorded delivery. Also, that the copy that was given by hand to site was invalid because it wasn't given to the registered office in line with the contract. The court referred to Keating, which is a big fat textbook that concentrates on construction contracts, which says at paragraph 003, a wrongful termination by the employer or its agent normally amounts to repudiation on behalf of the employer. And it continues, the courts will construe a termination clause in accordance with its commercial purpose, but it may require strict compliance with any condition precedent. Here, because the council had picked up the phone on the Thursday, the day the email was sent, it was actually held in this particular case that Thomas Barnes had failed to follow the correct termination procedure. So in other words, the termination notice under the contract was invalid. But luckily for them, the termination letter also said, if this notice is ineffective, this letter takes effect as acceptance of the repudiatory breach. Now, of course, Thomas Barnes had left the site at the end of May anyway. The court decided that the contractor had already stopped all meaningful activity, that they could not have completed the work. There was no adverse effect on Thomas Barnes being removed from site 2 days earlier, because of course it was officially taken over on the Monday anyway, and therefore Blackburn with Darwen Council validly did accept Thomas Barnes's repudiatory breach. That was the termination part. The delay analysis part, I have to say, has produced ripples generally in the industry. And they looked at the issue of delay analysis. Both of the experts here who were looking at the planning side referred to the SCL protocol, the Society of Construction Law Delay and Disruption Protocol, which you can get for free. But they took different approaches. The protocol itself points out that it's there to provide useful guidance. It's not intended to be a contract document or a statement of the law. It's there for good practice and a benchmark of best practice. And importantly, item D, the recommendations should be applied with common sense, which is paragraph 11.2, which I've quoted in full there. This particular matter was to do with concurrent delay. And effectively, there are three possibilities. The SCL approach looks at the first in time. If one delay is causing a delay, subsequent delays are disregarded. Alternatively, if you remove the other delay, would this delay have delayed the works? If so, the contractor is entitled to an extension. Or an equal causative potency approach. So if there's two events causing delay, one is an employer risk, one is a contractor risk, the contractor is entitled to an extension of time. Here, the steel frame delay, which was an employer-caused issue, occurred before and continued during the roof covering delay, which was the contractor's fault. The judge in this case came to his own conclusions based on the evidence presented, expert evidence, witness evidence, and contemporaneous evidence, and did not fully accept either of the experts' positions. It was held in this case that Thomas Barnes was indeed entitled to an extension of time of 119 days, but they could only get prolongation costs for 27 of those days because part of the delay was their fault. This particular decision matches Keating's view, effectively, that in the event of a concurrent delay, that the contractor only gets the net costs in relation to the delay period, but does indeed get a full extension of time. Now, what did that actually mean in this particular case? Well, Thomas Barnes at this point was insolvent anyway. It meant that the council, whilst Thomas Barnes was entitled to 27 days prolongation costs, that was not enough in relation to the monies that had been paid and the termination to actually mean that any monies at all were paid to the liquidator in this particular case. So the council actually were very happy with the result. However, think about the costs. When one party wins, which I would probably say Blackburn probably overall won here, and the other party loses, then you would normally expect that Thomas Barnes would pay the council's costs. But of course, because Thomas Barnes in this case were insolvent, it is very likely that the council will probably have to pay their own costs. Now, I am sure this is the case that you have really all been waiting for. I described it as social media, but this is my favourite case of 2022. I will admit I followed all of the news reports about this case with great interest. Of course, it is the Wagatha Christie case, which is also known as the Vardy and Rooney case, and there are important lessons that construction companies can take from this particular case. It all started with this tweet where Colleen Rooney said on Twitter that someone has been leaking stories to the Sun newspaper, that she had posted a series of false stories about various issues, and because she had undertaken some very forensic investigations, she had worked out where the leaks had come from. And you can see at the bottom it says it's, and a series of dots, Rebecca Vardy's account. Now, again, I know some of you will know a lot about this, other people will not know so much. One of the things that I have got quite cross about in the press is the fact that lots of the press coverage has said things like, couldn't these two people settle this case? It's crazy that it's gone to court. Well, I agree with that. But in fairness, Colleen Rooney did make a series of offers to settle in May, October 2020 and January 21. But they were not accepted. And in June 2020, Rebecca Vardy took a claim in libel against Colleen Rooney. Now, in libel, you need to show that there has been a publication in writing, a tick, even for a tweet. That is a publication in writing. And secondly, that it is defamatory of the claimant. Actually, I probably think that that's also true as well, because effectively there was a breach of confidence. However, the interesting bit is that it is a defence to libel to show that the statement is true or that its disclosure is in the public interest. And remember, this is Rebecca Vardy taking the case, claiming libel, and Colleen Rooney defending her position. And she went on both grounds. Number one, the statement that I made, the tweet that I issued, is true. or in the alternative, it is in the public interest. Now, there wasn't just one court case here. There is at least 6 and maybe 7. So November 2020, this was not a good day for Colleen Rooney, because the court decided that the tweet was referring to Rebecca Vardy personally and not to her account. Do you remember the last line of the tweet said, "It's Rebecca Vardy's account"? It was held there that that was a personal attack, essentially. Then Rebecca Vardy lost a couple of interim cases. She tried to strike out Colleen Rooney's references to the relationship between her and the Sun newspaper, and also tried to exclude evidence. There was a final hearing in May 2022, a decision in July 22, and since then there have been a number of costs hearings as well. The decision that came out at midday on the 29th of July, I kid you not, I was refreshing the court's page, waiting for this to upload from about 11 o'clock that particular day. It was held that Rooney had established that the essence of the libel was true. In other words, that Rebecca Vardy had indeed issued the stories to the Sun newspaper, but she failed on the issue of public interest. Now, I'm going to say and admit that I was very interested. Doesn't that count as public interest? The court said, and again, these judges have got a beautiful way of wording things. They described it as the undesirable practice of information about celebrities' private lives being disclosed to the press. I don't subscribe to Hello Magazine or anything like that. I was very interested, though, in the particular court case here. So in particular here, the court said it was not reasonable to believe it was in the public interest to actually publish the tweet. Again, I'm not agreeing with this, particularly in relation to if someone was posting false stories about me, I'd want to make sure that the press was put right. And secondly, I'd want to actually say who done it as well. Anyway, she lost on the public interest case. The interesting thing, though, really, and in relation to construction, is the evidence at trial. And the court, again, they're weighing issues up. They looked at the claimant's evidence. Now, that's Rebecca Vardy, because she's claiming that there was a libel against her. She said that effectively the claimant's evidence was not credible, that it was manifestly inconsistent with the contemporaneous documentary evidence, and that she was invasive or implausible. On the other hand, paragraph 11, the court found that the defendant, Colleen Rooney, and the people that she produced as witnesses, that they gave honest and reliable evidence. In relation to point 15, there were documentary evidence that was lost. So the loss of the WhatsApp conversation was deliberate rather than accidental, and they drew an inference that that would have supported Colleen Rooney's case. And of course, it was Rebecca Vardy who had lost that particular information. I have to admit that one of the stories I found very, very, very bizarre was what's been known as the flooded basement story. What actually happened here is there was a story released to the Sun newspaper that said Colleen Rooney is having a big house built, which indeed they were at that particular point, and the story said that the basement had been flooded. Now, of course, this was another false story that had been made up to see who was actually leaking the stories. The builder who was working on the Rooney's house actually phoned up Colleen Rooney and said, "I didn't know the basement had been flooded." And so Colleen Rooney at this point was still undercover and was unable to tell the builder that actually this was a story that she had made up. So actually the case itself is exciting, but of course I want to point out the costs. The costs budget was given by both parties in March 2021. Rooney said 402,000, Rebecca Vardy said 900,000. We get to the case in October 22. The solicitor for Colleen Rooney said that their costs were 2 million, with likely 350,000 occurred before the court case started. The court agreed that Rebecca Vardy had to pay on an indemnity basis. So in other words, it was the full amount that Colleen Rooney had incurred. However, a 10% reductions were applied because elements of Vardy's defence were upheld. Rebecca Vardy had to pay 800,000 on account here. And it's generally been reported that Vardy's costs herself was about 1.5 million. She would have to pay Colleen Rooney's costs of a further 1.5 million. And she also had to pay the costs, the legal costs of the Sun newspaper, because they were dragged into this issue as well. Hopefully, all of you take away from this particular case, you do not want to go near court at all. And really what I want to say to you is make sure you issue your notices as required by contracts. Luckily enough, we have no questions issued in the chat. So I will say, because we are just on 1:30, by all means, you can ask me a question via my email address. If you want a copy of the notes, of course, ask Heather or ask me, and we will get the notes out to you in the next few days. I sincerely hope you have enjoyed this very whistle-stop tour through cases of 2022. And hopefully you've had some laughs and gasps, and that we will see you on another Chartered ISIS seminar in the future. Thank you very much all for attending, and take care out there. Thank you.